May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Office of Special Assistants, starting on page 1 of the public meeting agenda with regard to the first item, that involving the complaint, the formal complaint of the Bureau of Investigation and Enforcement versus Uber Technologies, Inc., Gagan LLC, Razier LLC, and Razier PA LLC. We have the joint motion, Madam Chairman, that you have with Commissioner Coleman, as well as the statements of Commissioners Witmer and Powelson.
Thank you. Do I have a motion to call up this matter for consideration?
So moved.
Do I have a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powelson, recognizing Commissioner Coleman for the joint motion.
Well, thank you, Chairman. And before I jump into the motion, I just wanted to take a quick moment of time here to thank 4 of our Bureau directors that are with us this morning that all had a hand in this particular piece of business, those being our Law Bureau, our Administrative Law Judges, our Bureau of Investigation and Enforcement, and the reason that we're here this morning with our Office of Special Assistants. So a special thank you to each of you and to your teams who have done a superb job in getting us here this morning to this particular piece of business. With that being said, I would ask that that our joint motion be entered into the record as though we had read it in its entirety. Before the Commission are the exceptions of Uber Technology, Inc. and its subsidiaries Gagan LLC, Razier LLC, and Razier PA LLC, collectively Uber. In the initial decision of Administrative Law Judge Mary Long and Jeffrey Watson, issued on November 17, 2015, in the above captioned proceeding. Also before us is the motion to strike exceptions of Uber filed by the Bureau of Investigation and Enforcement on December 17, 2015. With this joint motion, we move that the motion of I&E be denied and the exceptions of Uber be granted in part and denied in part. As the exceptions of Uber, we find that the initial decision should be affirmed to the extent that it is held that Uber violated the Public Utility Code by providing regulated passenger transportation service without a certificate of public convenience, that a civil penalty should be assessed on a per-trip basis, and that Uber should be sanctioned for certain discovery violations. However, we find that mitigating factors be applied to significantly reduce the size of the civil penalty proposed by the presiding ALJs as detailed in the Office of Special Assistants in its proposed opinion and order. Adoption of this joint motion would result in Uber being directed to pay $11.365 million in civil penalties. Given the size of the recommended civil penalty in this matter and a substantial reduction from what was recommended by the administrative law judges, it is appropriate to offer some additional context. Let me first address the reduction in the civil penalty. We find that the recommended fine should be reduced to $11.365 million for 2 reasons. 1, Uber has modified its internal practices to comply with the Commission's imposed conditions on its current authority. And 2nd, Uber and its affiliates have not demonstrated any significant compliance problems since the grant of emergency, temporary, and later experimental authority. We agree that Uber has earned some relief from the fine recommended by the presiding ALJs given its performance over the last year and relatively few complaints that have been filed with the Commission. The civil penalty that is being adopted today is a very substantial reduction from what was recommended by the presiding ALJs and is significantly less than the $1,000 per violation maximum that is often levied against smaller carriers for violations of the Public Utility Code. This reduced penalty demonstrates that the Commission is more than willing to compromise in order to achieve outcomes that service the public's interest. Some would argue that while Uber has violated the Public Utility Code, the size of the civil penalty should be reduced to a much smaller number than what is proposed in the joint motion. So why issue such a large record-setting civil penalty appropriate? It must be recognized that Uber has deliberately engaged in the most unprecedented series of willful violations of the Commission's order and regulations in the history of this agency. While we cannot disclose the number of proven violations as this data is considered proprietary, This figure, in the many thousands, far exceeds any prior case involving the Commission. A record number of proven violations should be expected to result in a record-setting fine. We believe that any additional material reduction in the civil penalty in this case would jeopardize the future regulation of transportation network companies in Pennsylvania. In recent decades, we have witnessed first movers in area of new technology obtain market-dominant positions in relatively short order. While some would likely disagree, it is not unforeseeable that Uber and its affiliates will obtain a market-dominant position in passenger transportation services in this Commonwealth in the near future. Given this possibility, it is necessary that Uber be required to pay a civil penalty commensurate with the quantity of proven violations to discourage future unlawful behavior. This resolve demonstrates to Uber and to others in this industry that future unlawful operation will not be tolerated and thereby incentivize them to fully comply with the laws of this Commonwealth. If the Commission is unable to impose a civil penalty that reasonably corresponds to the very large number of proven violations, when would it be able to do so? Would the message we send, albeit unintended, be that Uber is too big to fine? On a related issue, the parties in this case were directed to address whether refunds or credits would be appropriate remedy for service provided in violation of the code. While we agree that the Commission has the authority to order this remedy, we conclude that we should not apply it in this case. We find that the civil penalty we have adopted insufficient for the proven violations. In conclusion, we recognize that the service provided by transportation network companies is very popular with consumers and is meeting the need that incumbent passenger carriers were not providing. Accordingly, we are pleased that the new transportation options are available to customers throughout the Commonwealth. We look forward to working with our colleagues and the General Assembly in crafting regulatory scheme that services the public interest in a safe, modern, and affordable passenger transportation service in this Commonwealth. Therefore, this morning we move that the initial decision Administrative Law Judges Mary Long and Jeffrey Watson issued on November 17, 2015 is adopted as modified by this joint motion, and that the Office of Special Assistants prepare an opinion in order consistent with this joint motion.
You have heard the joint motion. Is there a second?
Second.
Second by Vice Chairman Place. Under discussion, I would recognize Commissioner Witmer.
Thank you, Madam Chair. I'd like my statement entered into the record as if I had read it in its entirety. Before us today for consideration and disposition are the various exceptions and replies to the initial decision of ALJs Mary Long and Jeffrey Watson regarding the violations of the Public Utility Code of Uber. In the initial decision, the ALJs determined the following. 1, that Uber met the definition of a common carrier and was required to have authority from the Commission in order to operate. 2, Uber clearly held out its service to the public. And 3, the drivers who provided the transportation did not hold valid certificates of public convenience. The ALJs found that each trip provided by Uber without a certificate of public convenience constituted a distinct, identifiable, and separate violation of the code, and the Commission was authorized to assess a civil penalty of up to $1,000 for each violation. The ALJs also set forth the 10 factors that the Commission's policy statement requires, warranting consideration for the appropriate civil penalty. And while I don't believe that it's necessary to discuss all the factors, I agree at the outset that a per-trip penalty is warranted in this proceeding. The entrance of Uber into the marketplace provided an immediate and substantial benefit to customers as a competitive alternative to traditional call and demand service. Uber provides wide-ranging, fast, and user-friendly transportation, often to underserved areas. And as I have stated previously, this innovative use of the public space should be encouraged in a way that is consistent with the Commission's mission to protect the public interest, further economic development, and foster new technologies. As part of our mission and as new technologies develop, we are obligated to periodically review our regulations to determine whether or not they have kept pace with current industry practices and standards and this includes the transportation industry. Against this backdrop, I agree that Uber meets the definition of a common carrier and was obligated to obtain commission authority to operate prior to offering transportation service. Admittedly, Uber's compliance with our prior regulations and orders has been uneven. Providing transportation without requisite authorization from the Commission is a serious violation of the code and removes the Commission's ability to fulfill its responsibility of regulating the safety and reliability of common carriers. Similarly, Uber's decision to violate our July 2014 cease and desist order constitutes intentional conduct that ignored an explicit Commission directive. For these reasons, a substantial penalty is warranted. However, this case also presents significant mitigating factors that should be considered and weighed in assessing a civil penalty. First, there is little evidence to demonstrate that Uber's actions resulted in actual harm. While 9 accidents are documented during the time Uber was non-compliant with the code, none of these crashes involved bodily harm, and no evidence was presented that any of the drivers were uninsured or that Uber refused any insurance claims relating to the accidents. Another mitigating factor to be considered in this case is the number of customers affected by Uber's conduct. From February 11th, 2014, when Uber entered the marketplace and began offering transportation services, until August 20th, 2014, when the Commission granted Uber emergency temporary authority, the Commission received not one consumer complaint regarding Uber services, and the customers who used the platform sought out and willingly requested the service. Customers using Uber's application freely entered into a contract with the company and agreed on both the terms of the service and the price of the transportation services being offered. By all accounts, customers received exactly the service they requested. Finally, in considering additional relevant factors, I believe the recommended civil penalty is egregious, especially when compared to other cases in which the Commission has assessed substantial civil penalties for violations of the code. Several Commission cases wherein we assessed substantial civil penalties involved incidents of serious bodily injury, fatalities, significant property damage, and/or patterns of unsafe business practices that jeopardized the public's safety. I think these prior cases should instruct the civil penalty assessed in the instant case and guide us to a more measured and reasonable outcome. As one example, the largest civil penalty ever levied by the Commission was $1.8 million against an electric generation supplier for deceptive marketing practices of variable rate products, resulting in significant financial harm to customers. Although EGSs and TNCs are not directly analogous, the stark contrast in outcomes between these two cases is striking, particularly when considering that in the EGS case, action was taken against the will of customers and resulted in actual harm. In the instant case, the company was responding to market demand by providing a requested service about which the Commission received no consumer complaints. Yet, our action today levies a penalty several times higher than the largest fine assessed on a company whose conduct caused actual harm to consumers. I cannot support such a grossly disproportionate outcome, and for those reasons, I respectfully dissent.
Thank you, Commissioner Witmer. Commissioner Powelson.
Thank you, Madam Chair. I better get my statement in before President Clinton gets to the podium here. He'll read it for me. Before us here this morning are the exceptions filed by Uber Technologies and its subsidiary to the initial decision offered by the Office of Administrative Law Judge on November 17, 2015. And let me also join Commissioner Coleman in thanking the work of our bureaus. This is a very difficult case. We understand that. It's been very pressing of one's time. I think I was once quoted as saying this is exhausting, and it certainly has been. But Uber's operations as a motor carrier, and this is the common theme amongst the 5 of us here this morning, they operate it without a license, and it certainly constitutes a serious violation of the Public Utility Code. The Commission takes its duties to protect the traveling public in a very serious way and approaches any case of motor carrier operating without a certificate as a serious offense. And I think we all take that to heart when you look at the work that our transportation safety personnel do in areas all over the state inspecting vehicles. And this is no different. However, the initial decision was correct in its finding that by operating without a certificate during the early part of calendar year 2014, Uber committed serious violations of the Public Utility Code that warrants a substantial penalty. However, when determining the penalty amount, the Commission cannot overlook the existence of several mitigating factors in this case. First, when Uber began operating, the service it provided did not nearly fall in any of the categories of motor carrier service in our regulations. And I'm proud of the work that our team did in, one, the en banc hearings that we had, and like every other commission that has oversight of now transportation network companies, developing a record, and more recently, moving forward with our Transportation 2.0 initiative. That is why the Commission ultimately, by the way, as we solved this transportation calculus equation to get this entity legal here in the state, we ultimately granted Uber a certificate of experimental authority instead of categorizing Uber as a call or demand service or any other existing category of motor carrier service, excuse me. This issue has since been resolved both because Uber voluntarily submitted to our jurisdiction and with this week's Commonwealth Court decision finding that the Commission acted appropriately in exercising its jurisdiction over Uber. However, this does not change the fact that when Uber launched its operations here in the Commonwealth of Pennsylvania, they were operating in a legally gray area. The Commission should take this into account when assessing a penalty, a civil penalty here this morning. As a result, I believe the penalty for the period prior to the cease and desist order should be substantially reduced than after the time being looked at here today. Another mitigating factor that should be considered, as there's very little evidence on the record that Uber's actions caused any actual harm, and I think Commissioner Witmer alluded to that in her statement. And I think this is keenly relevant because in our rulemaking adopting the penalty factors, the Commission clearly stated that it is only proper to consider actual harm when determining whether to assess a higher penalty amount. Thus, it is legally incorrect to consider any potential harm to the traveling public as a result of Uber's operations. Moreover, in this case, the only actual harm documented includes a small number of accidents that occurred while Uber was operating without a certificate. And while these accidents certainly caused property damage, the number of accidents is extremely low considering all the overall amount of rides during the period. And plus, the record evidence demonstrates that none of these incidents caused bodily injury, nor is there any evidence that Uber or its drivers were uninsured during this time or refused any insurance claims relating to these particular incidents. Moreover, when the Commission ultimately certificated Uber, we largely affirmed the insurance limits and driver safety criteria that Uber had already had in place before it was certificated here in the Commonwealth. Thus, it is unpersuasive to argue that there was an actual safety risk as a result of Uber's operations. Additionally, it cannot be overlooked that customers who requested Uber's services during this period did so willingly. Given the high-profile nature of this issue, many of Uber's customers, as I commonly refer to them, the Uberites, likely sought out the service despite knowing that Uber was operating illegally. These circumstances make it difficult to argue that anyone was harmed as a result of Uber's actions, and certainly do not support assessing the highest penalty in the history of the Commission. Now, another mitigating factor is that Uber currently has authority from the Commission to operate on an experimental basis. And since obtaining that authority, there have been no compliance problems, and Uber has demonstrated a continuing willingness to comply with Commission directives. And I'd also add, as a former Chamber of Commerce executive and someone who served on a United Way board in my county, they've been a good corporate citizen here in Pennsylvania as well. Finally, it's important to consider the overall penalty amount in light of past Commission decisions. As Uber asserts in its exceptions, many of the cases where the Commission has imposed high penalties involved serious bodily injury, fatalities, significant property damage, or a pattern of unsafe business practices that jeopardize the overall public safety. In fact, as Commissioner Witmer alluded to in her statement, the largest single penalty imposed by the Commission for a case involving a fatality was $500,000 where a natural gas explosion resulted in 5 deaths. And I know a little bit about that particular tragedy. And in that case, again, a $500,000 fine levied on a gas distribution company where we had loss of life and property. Also relevant here is the highest penalty ever imposed by the Commission is $1.8 million. Excuse me, Commissioner Witmer, that was the one you were referring to. In that case, the Commission penalized the electric generation supplier for enrolling numerous customers in a guaranteed savings plan and intentionally failed to honor its guarantee. Unlike here, that case involved a substantial amount of actual financial harm to a large number of customers resulting from intentional and deceptive marketing practices. In determining a final penalty amount for Uber, the Commission cannot disregard the existence of these several persuasive mitigating factors. If the Commission imposes the maximum penalty amount on Uber based solely on the number of violations, it will be an extraordinarily, obviously, high amount. However, it is improper for the Commission to end its analysis there. Rather, the number of violations should be one element in determining the total fine. A reasonableness review of the total fine in comparison to past Commission decisions is equally important here this morning. After all, it is well-settled law that the Commission retains broad discretion in determining a total civil penalty amount that is reasonable on an individual case-by-case basis. Here this morning, Uber gave people rides who asked for them. They willingly hit the app or downloaded the app on their iPhone and willingly accepted rides from this entity. It did so, however, without the Commission's blessing, which warrants a substantial fine, but not 5.5 times the largest fine ever issued in Commission history. After weighing all the relevant factors, I believe the overall civil penalty assessed here this morning should be $2.5 million, and I think it's appropriate. Lastly, I'm a little dismayed by the Commission's Bureau of Investigation Enforcement for refusing, let me repeat that, for refusing to engage in settlement discussions, especially when they entered into settlement discussions with a competitor who engaged in the same activity. And by the way, paid approximately 2% of the fine being assessed here this morning. Madam Chairman, that concludes my statement. Thank you.
Thank you, Commissioner Powelson. Is there any further discussion on the joint motion? Seeing none, all those in favor say aye.
Aye.
Any opposed?
Opposed.
The motion passes 3-0, noting the no vote of Commissioner Witmer and Commissioner Powelson. On the matter before us, as amended by the joint motion, is there any further discussion? Seeing none, is it okay to take the previous roll call?
Yes.
Yes.
Thank you. The motion passes 3-2. I said 5-0, I think, before. 3-2, noting the two no votes of Commissioner Powelson and Commissioner Witmer.